Hello, everyone. I'm Alan Candle, a partner in Husch Blackwell's Employee Benefits and Executive Compensation Group. I'd like to thank you for joining our program today on the impact of Secure 2.0 on employee stock ownership plans. So before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons to use during the program today. If you have any questions during the webcast, please submit by the question box. We'll try to answer all the questions during the webcast today, especially the softball questions. But if a fuller answer is needed, or if we run out of time, we'll answer later by email. A PDF of the presentation is available in the program materials folder. This program has been approved for legal education hours. And to report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be mailed to you tomorrow, along with the recording of the webcast for watching and sharing. Also, if you need a copy of the Secure 2.0 Act, let us know. Shoot either me or Jordan an email, and we'll send you a PDF of it. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. So along with me, my partner Jordan Burkamp will be presenting today. Jordan?
Yeah, hi everyone, and thanks for joining. My name is Jordan Burkamp. I'm a partner in the firm's Employee Benefits and Executive Compensation Group out of the Kansas City office. And for those attending who are not in Kansas City, if you're wondering, yes, I'm skipping the Chiefs Super Bowl celebration parade today to bring you all this wonderful ESOP knowledge. For those attending from Kansas City, thank you for sticking with us. I know it was a difficult decision between seeing Patrick Mahomes and the rest of the team or listening to Alan and me present on Secure 2.0. So thank you.
That's all for the housekeeping items. So let's get started with the program. Our agenda is going to include the Work Act, change to Section 1042 for S corporations, publicly traded ESOPs, changes to required minimum distributions, changes to EPCRS, which is the IRS correction program for qualified plans, retroactive amendments, Roth elections, the small employer credit, small balance cash outs, and the timing for amendments. Some of the ESOP organizations have said that the Work Act in particular is a major win for employee ownership, and the most important pro-employee ownership legislation since the legislation in the 90s allowing S corporations to have ESOPs. And the focus there is really on the first three items on the agenda: the Work Act, Section 1042 for S corporations, and publicly traded ESOPs. We're going to talk about some of the details of these provisions. Some of them are pretty short, and I think we'll need some context and background, and we're going to get into some of that, particularly on the Work Act changes. So the Work Act includes two provisions that could have a significant impact on the formation of new ESOP. The first one is the direction to the Department of Labor to issue a regulation for determining fair market value. The provision says that DOL shall issue formal guidance. Shall is not emphasized in the statute, in the act, but it's emphasized here because it's an important part of the direction. The DOL shall issue formal guidance for acceptable standards and procedures to establish good faith, fair market value for shares of a business to be acquired by an employee stock ownership plan. Now, all of the ESOP organizations, and there are three ESOP organizations in the U.S. One is the ESOP Association, ESCA, the ESOP S Corporation Association, the National Center for Employee Ownership. They've all been pushing for this for years. And I've participated in the ESOP Association's Washington Conference the last few years, and that includes lobbying the representatives in Congress. And this has always been part of what we've discussed with the members of Congress and more likely their staffers. But, you know, it kind of raises the question, why would these organizations and really the whole ESOP community want more regulation? Typically, you want less regulation because less regulation gives you more flexibility. The problem is that the definition of fair market value is really at the core of what makes ESOPs possible. It's also the primary substantive issue in virtually all litigation involving ESOPs. In terms of making ESOPs possible, any purchase of stock by an ESOP from a shareholder is a prohibited transaction. Also, if a trustee pays more than fair market value for the stock, then the trustee has breached his or her fiduciary duties on behalf of participants and beneficiaries. So to qualify for the prohibited transaction exemption, the ESOP can't pay more than adequate consideration. ERISA defines adequate consideration as fair market value, as determined in good faith by the trustee or named fiduciary pursuant to the terms of the plan and in accordance with regulations promulgated by the Secretary of Labor. So the Secretary of Labor, the DOL, published a proposed regulation in 1988, 35 years ago, but has never finalized the regulation. The Administrative Procedure Act governs the process for a federal agency to promulgate a regulation. It has to give notice to the public and an opportunity for interested people to participate in the process by submitting written statements, or if there's a hearing, appearing in person and giving oral testimony at the hearing. The agency then has to take into account all this input and can revise the regulation when it's finalized. The DOL has chosen not to go through that process. And the DOL historically has been skeptical of ESOPs. You know, in the ESOP community, we tend to view ESOPs as a way to make workers into owners. But the DOL view has been more suspicious as a way for owners to cash out at the expense of employees. And so rather than go through the process mandated by the APA for finalizing a regulation, the DOL has chosen to regulate through litigation. Litigation risk has caused a number of trustees, institutional trustees, well-regarded institutional trustees to exit the business. That's a hindrance to the formation of new ESOPs. Litigation has risk, it has cost. To defend an ESOP case, if you go beyond, if you don't win at the motion to dismiss stage, the defense costs are going to be very significant, typically in the high six figures, maybe in the seven figures. And the DOL has taken extreme positions that have resulted in a lot of expense for trustees and their insurers, which again, if insurance is not available, that also is a hindrance to the formation of new ESOPs. And let me give you an example. It should be pretty basic that the debt that an ESOP sponsor incurs in order for the ESOP to buy shares of stock of the company will reduce the value of the stock after the closing. It's kind of like a house purchase. And one case actually used this analogy. If the value of a house is $100,000 and the owner takes on an $80,000 mortgage to purchase the house, the equity after closing will be $20,000. Well, the same applies to the value of stock that's held by an ESOP. And like I said, some courts have recognized this, but not all. A regulation could clarify that a transaction valuation is not faulty just because the post-transaction valuation takes into account debt that was incurred for the valuation, or that was incurred in order to do the transaction. The DOL has entered into 6 process agreements with ESOP fiduciaries. And this is part of the settlement of ESOP litigation. In all of these cases, the DOL's allegation has been that the trustee paid too much for the shares. So each process agreement sets out requirements that apply to that specific trustee whenever an ESOP buys or sells shares of stock of the company that's not publicly traded. And while the process agreement is with a specific trustee, the DOL intends the process agreements to be generally applicable, the same as a regulation would be. They're posted on the DOL website, and the DOL spokespersons have said that others would do well to take notice of the agreement's provisions. And these process agreements have provisions that are not in the 1988 proposed regulation, and probably wouldn't make it into a final regulation after going through the notice and comment period. I can give you a couple of examples from a recent process agreement, or the most recent process agreement, I believe, with Farmers National Bank. One part of that agreement deals with control premium. And it says that if the ESOP pays a control premium, the ESOP has to have control in fact. So what is control in fact? According to the process agreement, it includes the ability to appoint and remove the company's officers, the ability to set management compensation, the ability to authorize or veto major capital expenditures, and other restrictions or other things that should be included in this control. So the problem is that these indicia of control are board issues. These are not shareholder issues. The trustee of the ESOP is the shareholder, is not on the board, and is not a substitute for the board. And so, I think that this particular part of that process agreement, which again, the DOL intends other trustees to follow suit, probably wouldn't survive in a final regulation. Also, with respect to indemnification, ERISA allows fiduciaries to be indemnified, but this process agreement says that the trustee is prohibited from entering into any agreement providing for the advancement of defense fees and expenses unless an entirely independent third party determines that no breach of fiduciary duty has occurred. And if fees and costs are advanced, then collateral has to be posted to guarantee repayment if a court determines that a fiduciary breach occurred. Well, this makes the indemnification basically meaningless. And again, why would the ESOP, the organizations representing the ESOP community, be advocating for regulation? It's because the DOL has taken some pretty extreme positions, and the idea is that a regulation would provide more certainty so that trustees and companies and selling shareholders can decide how to act in accordance with the applicable guidance. The other part of the Work Act is the Employee Ownership Initiative. This is to be a program within the Department of Labor to promote employee ownership. It has a couple of parts. It will support states' programs to promote employee ownership, provide additional funding to existing programs. The purposes are to provide education and outreach to employees and employers about employee ownership, business ownership, succession planning, provide technical assistance so to assist in the process of workers becoming owners, and to train employees and employers regarding open book management. The funding that is provided, you see here what it is. So it is funded. The thing is that these funding levels appear to be on the modest side. $4 million in 2025 spread across 50 states is $80,000 for 2025. It doesn't really appear to be a very robust funding, but it's a start, and it's an important start. I think Jordan's going to talk now about Section 1042 for S corporations.
Yeah, thank you, Alan. So and as Alan mentioned, basically what we're going to go through these changes, but in order to understand the changes, we're going to give a little background or history, which, if you're new to ESOPs, it's going to be a good primer, or if you're a seasoned veteran, a good refresher on some of these rules. So the current Section 1042 rules provide that no gain is recognized by a selling taxpayer of a C corporation or on sales of C corporation stock to an ESOP if certain conditions are met. It's important to note that because the selling shareholder's basis in the stock sold to the ESOP carries over to the qualified replacement property, this is actually a tax deferral, not an elimination of tax. The caveat being that in certain situations it can be elimination of tax, such as transfer at death, where the selling shareholder's estate receives a step-up in basis. We joke with our clients that's a pretty steep price to pay for elimination of tax. But so the requirements to obtain 1042 deferral are: the stock sold to the ESOP must be of a domestic corporation that is not publicly traded, and the corporation must either sponsor the ESOP or be a member of a group of related entities that sponsor the ESOP. So in other words, it cannot be shares of an unrelated corporation that is sold to the ESOP. The selling shareholder must have held the stock for at least 3 years prior to the sale of the ESOP. And immediately after the sale to the ESOP must own at least 30% of each class of outstanding stock, or at least 30% of the total value of the outstanding stock of the corporation. And then in order to get the deferral, so you transfer your basis to what's called qualified replacement property. So the shareholder must buy this qualified replacement property, which is defined as certain types of securities, including stocks, bonds, notes, issued by a domestic operating corporation other than the corporation that issued the stock involved in the 1042 transaction. And then the final requirement is that the shareholder must purchase this qualified replacement property within 15-month period, beginning 3 months before the date of the sale to the ESOP and ending 12 months after the date of the sale to the ESOP. So what did the Secure 2.0 do for 1042? What it did is it expands this 1042 deferral to an S Corp shareholder who sells to the ESOP. However, it's limited. It's unlike the C Corp 1042. The S Corp 1042 is limited to 10% of the amount realized on the sale of the S Corp stock to the ESOP. This Secure 2.0 expansion to S Corps is effective for transactions made after December 31, 2027. Now, the impact of this, so Alan and I do not expect this to move the needle much if you're a motivating or you're a seller and you're on the fence on whether or not to to sell to an ESOP, this 10% deferral probably isn't going to move the needle for you that much. The largest impact we think is going to be on deal structure. So the sellers made the decision they want to sell to an ESOP. They're an S Corp. Before this, our common deal structure that we like to utilize for various reasons that can be a webinar in and of itself is that the corporation redeems the shareholder and the corporation is the one that sells the stock to the ESOP, not the shareholder. It doesn't sell the ESOP. However, in order for an S Corp shareholder to take advantage of this 1042 deferral, that structure would need to change. It would be the shareholder, him or herself, selling the shares directly to the ESOP. So it would change deal structure in order to take advantage of this. The last Secure 2.0 change that is specifically ESOP targeted and only affects ESOP is this concept of publicly traded ESOPs. And I won't spend a whole lot of time on this because this is such a targeted change that not many people will have to deal with it or come across it. But basically, the Secure 2.0 updates certain ESOP rules related to whether a security is, quote, publicly traded employer security and, quote, readily tradable on an established securities market. It basically allows certain non-exchange traded securities to qualify as publicly traded so long as the security is subject to quotations by at least 4 dealers on an SEC-regulated quotation system, is not a penny stock, and is not issued by a shell company, and has a public float of at least 10% of outstanding shares. So the Senate summary of Secure 2.0 says that these updated definitions will allow highly regulated companies with liquid assets that are quoted on non-exchange markets to treat their stock as publicly traded. Last week, Alan and I attended the ESOP Association Professionals Forum. It was mainly discussed that this is a targeted change at banks that trade on these non-exchange markets, but that would like to be ESOPs or would like to avail themselves to be an ESOP. The effective change for this is December 31, 2027.
So the Secure 2.0 Act, again, this is getting into changes that affect all qualified plans, including ESOPs. The change with respect to required minimum distributions has 2 parts to it. One is to delay the triggering date for RMDs, required minimum distributions, and the other is to reduce the excise tax for a failure to comply with the minimum distribution requirements. In the old days, before the first Secure Act, the required beginning date, which is the date by which payments are required to begin from a qualified plan, was April 1 following the calendar year in which an employee attained age 70 and a half or retired, whichever was later. In the case of a 5% owner, the trigger is not retirement. It would be just the reaching that age. Secure Act, the original Secure Act delayed the triggering date from age 70 and a half to age 72. And then Secure 2.0 delays the age again in 2 phases. The first is to age 73 for somebody who attains age 72 after December 31, 2022, and before January 1, 2033. And it moves up to age 75 for an individual who attains age 74 after December 31, 2032. It's possible to keep the older minimum required beginning dates as a plan requirement, not as a statutory requirement, but that's something that plan sponsors would need to make a decision on. I think most of our clients are not doing that, are not keeping the old RMD dates. They're just going with whatever the statute provides. There's a technical glitch in the Secure 2.0 Act. In the case of somebody who is born in 1959, or somebody who was born in 1959 will attain age 73 in 2032, which is before January 1, 2033. And so the triggering date should be age 73 for that person, but that person also will attain age 74 in 2033. In other words, after it says before December 31, it should say after December 31, 2032, in which case the triggering age will be 75. So I think this is going to require either technical corrections or the IRS guidance on what happens with somebody who is born in 1959, although it won't be relevant until we're a few years down the road. The other part of the RMD changes is the excise tax. Before Secure 2.0, there was an excise tax of 50% of the amount that should have been distributed but was not. That applies to the distributee. The Secure 2.0 Act reduced the excise tax generally to 25%, effective now in 2023. This is reduced to a 10% excise tax if the taxpayer receives a distribution of the misdistribution during the correction window. And the correction window begins generally when the excise tax is imposed. It ends on the later of the date of that the IRS mails a deficiency notice, the date on which the IRS assesses the tax, and that's a technical term, and the last day of the second plan year that begins after the end of the taxable year in which the tax is imposed. So, I mean, to me, there's a little bit of an interesting question. It's only interesting because I tend to get nerdy about these things. When is the tax actually imposed? It seems from the statute that it's not imposed due to any IRS action, because the statute says that the tax is imposed when there's a failure to receive a minimum distribution. So that would seem to be as a year expired. Let's say 2023, there's a failure to take a required minimum distribution. It would seem that the tax would be imposed in 2024 because there's not a failure until the end of 2023. Somebody just feel free to correct me on that, but that seems to be what how the statute would the result that would flow from the statute. In which case, the window would not end before the end of 2026. In terms of correcting a failure, an RMD failure, there are really two consequences to a failure. One is a plan qualification failure, and this is something that can be corrected under the self-correction part of the IRS correction procedures. And Jordan's going to talk in a couple of minutes about changes to EPCRS, which is an easier way of saying the IRS correction procedures. The other consequence of a minimum distribution failure is the excise tax. Excise taxes can't be corrected under the self-correction program. And even though, and Jordan will talk about the expansion of EPCRS, that self-correction is being expanded by Secure 2.0, it doesn't seem that it's expanded enough to include a waiver of an excise tax. So probably the VCP program, the voluntary correction program, is going to be required in order to waive the excise tax on a failed minimum distribution, which requires submitting an application to the IRS, disclosing the issue, proposing a correction, and paying a user fee. If you're dealing with a 10% excise tax, that might remove some of the incentive to go through the process of VCP in order to get the excise tax waived. My experience has been that the difficult RMD failures have gone on for way more than 2 years. Often it's with a failure to pay a minimum distribution in connection with the death of a participant, and where the people who were involved with administering the plan didn't realize that who was to be paid. If typically the default beneficiary is the estate, maybe the relatives didn't want to open an estate, and so it kind of languishes, or not sure how to deal with it, or goes on for a long time. That's typically the context in which I've seen minimum distribution failures in an ESOP. These rules on the excise tax well, first of all, the requirement minimum distribution rules are effective in 2023. The excise tax on the failure to take RMDs is effective also in 2023. So now we come to our first poll question. The question is, has your ESOP or other qualified plan failed to make required minimum distributions? So we have three possibilities here. Yes, it happens all the time, once or twice, and never. So I'll give you half a minute or so to submit your responses. Well, looks like we're approaching 50% response rate. I think that's not bad for a survey. So let's see what the results are. Most people say they've never had a minimum distribution failure. Well, that's good. The second poll question is, if your plan has failed to make required minimum distributions, how is it addressed? So one possibility is VCP. Another possibility is self-correction. Third possibility is we ignored it because we hoped it would go away.
Luckily, based on the responses to the previous question, there might not be too many people have to worry about this.
Yeah, I mean, unfortunately, the third response is intended to be humorous, but it's also it's based on real life experience. That's what many employers have done. So let's see the results. Some have done VCP, some have self-corrected. Okay. Thank you.
Well, that's a perfect lead in to our next topic of the changes to the EPCRS. So the EPCRS stands for the Employee Plan Compliance Resolution System. It's quite the mouthful. And it's a comprehensive system of corrections for failures related to qualified retirement plans. Relevant to today's discussion for Secure 2.0 and ESOPs are the self-correction program, the acronym is SCP, or the voluntary correction program, VCP. And Alan had touched on somewhat of the distinctions between the two. But as the name implies, self-correction program, the plan sponsor self-corrects internally within the plan and does not seek IRS approval, doesn't file anything with the IRS approval or anything. The IRS is not involved. Conversely, with VCP, or the voluntary correction program, the plan sponsor files an application with the IRS, pays a user fee, provides the IRS with the correction or the proposed correction if it hasn't been made yet. Generally, there's a negotiation. If the IRS doesn't approve right away with the correction, they might ask questions or ask us to change something. But in the end result, the IRS approves of the correction, and then in return, the plan sponsor receives a compliance statement signed by the IRS. And so prior to Secure 2.0, whether a plan could go through SCP or had to go through VCP and file with the IRS depended on whether the failure was a, quote, significant failure or an insignificant failure. And and also the timing of the correction of the failure. And for those who have ever went through SCP or thought about going through SCP, you know how tedious of the determination of whether a failure is significant or insignificant. It was a completely facts and circumstances analysis, and basically you looked at various factors, including the percentage of plan assets and contributions involved in the failure, the number of years of the failure occurred, the number of participants who were affected relative to the number of the participants in the plan, and then the number of participants who were affected as a result of the failure relative to the number of participants who could have been affected as a result of the failure. And no single factor was determinative. And so then after you did that, you determined whether it was significant or insignificant. If you determined that the failure was significant, you could only utilize SCP if the correction was substantially completed by the last day of the third plan year following the plan year in which the failure first occurred. And note the timing there. The last day of the third plan year from when the failure occurred. So it's based on when the failure occurred, not from when you discovered the failure, which oftentimes could have been after 3 years, even if the failure occurred previously, right? So I'm going to pause here. We had a question from an attendee. What are the upsides, downsides of SCP? What are the upsides, downsides of VCP? So yeah, I'll address that real fast. So SCP, the upside is that you do that internally, right? You work with your advisors, you make the correction, and I should note that regardless of whether you do SCP or VCP, the correction is the same. You follow the correction guidance published by the IRS, and you make the correction based on that guidance. So the upside to the SCP is that you have less legal fees. You don't have to file anything with the IRS. The downside is you don't get a compliance statement, right? So theoretically, if the IRS came and audited the plan and disagreed with how you corrected it, or disagreed that it was not a insignificant failure and it was in fact a significant failure, they could start an audit and make life miserable, right? Conversely, for VCP, the upside is just that, right? You get a compliance statement, and the IRS has approved of the correction, so they can't later come back and say, actually, we disagree with that. The downside is they may not approve of the correction, and they may make you correct for more years than you were wanting to correct, or for more dollars than you were wanting to correct, or for whatever reason, right? I mean, they could disagree with it completely. The downside of VCP is that you also have to pay a user fee. There's some more legal costs involved. Your attorneys have to file with the IRS, negotiate with the IRS. But then a quick summary of upsides, downsides of SCP versus VCP. So now we'll get into, okay, that's the background. That is what is EPCRS. What has Secure 2.0 done? So what Secure 2.0 does is it introduces a new defined term, eligible inadvertent failure, which is defined to include any failure that occurs despite the existence of plan practices and procedures designed to prevent the failure, and that is not, quote, egregious, and we'll get into what egregious is in a second, and not directly or indirectly related to an abusive tax avoidance transaction. And then it goes on to say, Secure 2.0 says SCP, so the self-correction program is expanded to cover any eligible inadvertent failure if the correction is begun before the IRS identified the failure and the correction is completed within a, quote, reasonable period after the failure was identified by the plan, right? And so there's the first key difference. Correction completed within a reasonable period after being identified by the plan, not when the failure occurred, but when it was identified. So what is the effect of this on EPCRS? Really, the broad effect is that it mostly makes moot the distinction between a significant failure and an insignificant failure. That whole tedious process of going through the factors. This defined term, eligible inadvertent failure, encompasses both significant failures and insignificant failures. Also, as I just mentioned, the new correction period is based on when the failure is discovered, not when it's occurred. So effectively, the SCP correction period is indefinite from the time the failure occurred, right? I mean, it could have a number of years between when it occurred and when you actually discovered it. And then it's important to note that these changes to the EPCRS are effective now. I mean, the Secure 2.0 made these changes effective as of the date of the act. So a couple open items or open issues. So as Alan mentioned earlier, EPCRS is actually an IRS program, right? And as we recall from our civics, there are 3 branches of government, right? Congress is the legislative branch, and the IRS falls into really the executive branch, enforcing the rules, right? And Congress sets the law, and the IRS enforces the law. And so the IRS has its own leeway on how it enforces those laws. But Secure 2.0 said, IRS, you have 2 years. We're giving you 2 years to update your EPCRS based on what we've said in this Secure 2.0. Now, with that updated guidance, the IRS will have, considerable latitude to define what is, for example, what's a reasonable period after you discover the failure. How long do you have to correct the failure in order to be able to use SCP? And then it'll also still have pretty general power to limit SCP. For example, I mentioned earlier that this new defined term, eligible inadvertent failure, cannot be a, quote, egregious failure. Well, currently, EPCRS defines an egregious failure very narrowly. It's consisting of 3 things. 1, a plan that has consistently and improperly covered only highly compensated employees, or a plan that provides more favorable benefits for an owner of the employer based on a purported collective bargaining agreement, so that you faked a union agreement, or where a contribution is made to a plan on behalf of a highly compensated employee that is several times greater than the annual benefit limit. Those 3 very narrow definitions of what's egregious. So perhaps they expand what they've determined egregious in order to limit SCP. And then the final thing, and I guess I should have said this back when I was going about the upsides, downsides of VCP. Secure 2.0 did not change that the only way you can get an excise tax waiver, so for example, what Alan was talking about, an excise tax waiver of RMDs, is you have to go through VCP, and the IRS has to approve it, and you have to get a compliance statement, and that compliance statement can waive the excise taxes. You still don't get an excise tax waiver through SCP. So that leads into our next topic, which are retroactive amendments. So currently, a plan amendment must be adopted by the last day of the plan year in which the amendment is to be effective. So if we wanted an amendment for 2023, we had to adopt it by December 31, 2023. What Secure 2.0 changes is that a plan can be retroactively amended to increase, not decrease, only increase participants' benefits if the amendment is adopted no later than the due date of the tax return of the year for which the change is to be effective, provided that the amendment doesn't cause a plan to fail to meet some other tax code requirements. So, for example, it doesn't say we can give contributions that exceed the annual benefit limit. This change to amendments is effective for plan years beginning after December 31, 2023. The largest effect of this is that it brings in line a change that occurred in the original Secure Act. So the original Secure Act made a change or an update that allowed a plan, even an ESOP, to be retroactively created or adopted, as long as the plan was adopted by the due date of the tax return for the year in which the plan was to be enacted. So, for example, if you wanted to adopt, if you didn't have a plan yet or you didn't have an ESOP, here on February 15th, 2023, you could still adopt an ESOP effective January 1, 2022. And so what this change to the retroactive amendments is it does the same thing with amendments to existing plans. The other slight change this could affect is maybe changing the analysis of doing a retroactive plan amendment to make a plan correction under SCP. SCP has certain rules that allows you to also do retroactive plan amendments to increase benefits if that amendment would correct a failure. So then let's check time. Okay, so that gets us into overpayments, which is also an EPCRS concept. So the current EPCRS guidance requires a plan to recover overpayments above a de minimis amount, which they define as $250. So if you've made an overpayment above $250, you had to seek recoupment. And what did that mean? So that required plan sponsors to effectively notify the participant, hey, you weren't entitled to this overpayment. And also the overpayment you received is not eligible for any tax favorable treatment that it may have received. So for example, if someone received an overpayment and they rolled it over to an IRA and didn't pay tax on it. And then for ESOPs, the EPCRS rule said the plan sponsor was required to request the participant to return the overpayment, which if the participant was no longer employed or no longer with the company, happened about as many times as you could imagine. Then, depending on the reason for the overpayment and if the participant did not return the overpayment, the plan sponsor was required to contribute that overpayment back to the plan to effectively make the plan whole. So what did Secure 2.0 change? Basically, it gave, so it changed ERISA to give plan administrators the discretion on whether or not to seek recoupment of overpayments from participants or beneficiaries or plan sponsors or contributing employers. Now that's provided that a participant's non-forfeitable account is not reduced because of the overpayment, or plan fiduciaries, except if the fiduciary's breach is one that caused the overpayment itself. And then as far as the tax code, Secure 2.0 changed the tax code to provide that if a plan does not seek overpayment or recoupment of an overpayment, then the plan would not be deemed to have a plan failure unless that overpayment violated some other tax code requirement. Again, for example, if the overpayment created an annual benefit limit issue. So then conversely, so Secure 2.0 says, hey, we're going to give you the discretion to recoup overpayments. Conversely, we're going to change the rules if you decide to recoup overpayments or seek to recoup overpayments. And those rules, so it updated ERISA to say if a plan decides to seek recoupment of overpayments, the plan cannot charge interest or fees on the recouped overpayment. The recoupment cannot be sought from a beneficiary if the overpayment went to the participant. So for example, if a participant received an overpayment 2 years ago, died, the plan cannot then seek to recover the overpayment from the beneficiary on the account. A fiduciary cannot seek recoupment of an overpayment that occurred more than 3 years before the participant or beneficiary was notified of the overpayment. And the fiduciary can't use threats of litigation or seek recoupment through a collection agency or a third party. And then it further changed the tax rules regarding overpayments to say that if an overpayment was made to a participant or beneficiary and recoupment is not sought, so we let them keep it, that overpayment is now going to be treated as an eligible rollover. So basically it gets the tax favored treatment. Or conversely, if recoupment is sought and the participant actually pays it back, that payment back to the plan is treated as an eligible rollover into the plan. So now it's no longer forfeitable, right? I mean, it's not subject to vesting anymore. And these changes to overpayment rules are effective the date of Secure 2.0, which is important because at first glance, this is welcome relief regarding overpayments in terms of plan administration. But, no good deed goes unpunished. There are some holes now within the rules. So going back to what's still on this slide here, for example, ERISA now prohibits recoupment of an overpayment that's more than 3 years old. Conversely, the tax code requires recoupment of an overpayment that caused the plan to fail a tax limit. So theoretically, if a overpayment was 4 years ago that caused the plan to fail an annual contribution limit or an annual limit, now we have ERISA saying we can't recoup it, and we have the tax code saying we have a plan failure. So they're not congruent. These changes are not congruent with each other. And like I said, these changes are effective right now. So if you have overpayments that you discover right now or that occur in the future, we need guidance from the IRS and the DOL on these points because there are holes within these rules. So we'll need guidance there. So stepping away from plan failures aren't fun. They happen, but they're not fun. This one's a fun one, I think. This one's pretty interesting. So employer Roth contributions. And now this is not an ESOP specific change from Secure 2.0, but I think it has some pretty interesting aspects as applied to ESOPs. So the current Roth rules, or the prior Roth rules, I should say, were that Roth contributions go into the plan on an after-tax basis, and then they grow with tax-free earnings and are distributed at retirement without triggering any future income tax liability. Now, previously, Roth contributions were only employee contributions. So they are employee elected contributions to the plan. The employee elected to be taxed on the contribution, paid the tax on the contribution, but in exchange that grew tax-free, right? What Secure 2.0 changed is it includes or added to the definition of a Roth contribution both employer matching contributions and employer non-elective contributions, provided that the plan provides for Roth and that employee elects Roth. So that's an important point. These are not required changes. So, as an ESOP, and I'll get into that in a second, as an ESOP, you are not required to add this to your plan. And this change is effective at the date of this enactment of Secure 2.0, which, by the way, I don't know if we said, or maybe we glossed over it earlier on the call. The effective date of Secure 2.0 is December 29, 2022. So last December. So then that leads to some pretty interesting open issues as it pertains to ESOPs that may want to implement this. For example, if you're a new ESOP or a young ESOP and you still have debt outstanding from the purchase, the original purchase transaction, that's lowering the share price, and all things being equal, when that share price or that debt's paid off, the share price is going to go up. It seems pretty interesting that I could pay tax on that while the debt is still outstanding. And once the debt gets paid off, now my share value is even higher and I don't pay tax on that anymore. However, there's some potentially administrative issues with respect to the ESOPs that we're going to need IRS guidance on. The first is, Alan and I are interpreting that the changes made by Secure 2.0 would require, if an employee elected to treat an employer contribution as a Roth contribution, that's going to be included in the employee's wages for both income tax and FICA tax reporting and withholding. And so from an ESOP perspective, where the contribution may not even be in cash, or it's a contribution that is then used to pay the inside ESOP loan, which releases shares allocated to the participant's account. In other words, there's no cash for withholding. So you're going to have to use, or to the extent you implement this, you're probably going to have to withhold from the employee's other compensation. And then the second one is, from an annual contribution limit perspective, ESOPs can treat or use the lesser of the fair market value of stock allocated to the participant's account, or the pro rata share of the contribution, the ESOP loan payment, in terms of 415 annual limit rules, well, then the question is, will we get to use the tax for Roth treatment? Do we get to use the lesser of approach? Do we get to use the lesser of the loan payment or the value of the share allocated to the participant's account? My gut tells me no, you probably have to use the value of the share, but IRS guidance is needed. And this gets us to our last poll. Do you anticipate adding Roth to your ESOP or advising your clients on adding Roth to their ESOP? Give a few more seconds for some votes to come in. All right, well, let's check out the results. Yeah, possibly. Yeah, I mean, I think that's kind of been the consensus. Like I said, Alan and I attended the ESOP Association Professionals Forum, and we had a brief discussion on this from an administrative perspective. And there are these administrative questions outstanding, but I think it's a pretty interesting question when it comes to ESOPs to choose to be taxed on the value of share today as opposed to in the future.
Okay, well, I'm going to talk about a couple of expansion of tax credits. Before I do, there was a question I didn't see earlier, which is poses this question: an employee is less than a 5% shareholder, is age 72 as of December 31, 2022, and is still employed. When does the employee's required minimum distribution begin? That would be the April 1st following the year in which the employee retires, because that person has not is not age 70, does not attain age 73 after December 31, 2022, and they're less than 5% shareholder. So it would be, again, April 1 following the year in which the employee retires. There's another question, and actually we have 2 minutes left. So, and I think the questions are probably more interesting than the slides. So if I can just go to this next question, there are plans in our state that have already been allowing ESOP shares to be treated under the Roth rules. The plans were KSOPs. You know, I think that is probably where the you can have an in-plan rollover from a pre-tax account to a Roth account. And you could do that if in a KSOP, that because under the old rules, you couldn't have a Roth account if the plan was not a 401k plan, so it would have to be a KSOP. In that case, I think that would work, but this would allow new contributions to be treated as Roth without having to have the rollover.
Yeah, I think what that question highlights, Alan, is something I probably didn't address, is that, in which you just did, is that previously, in order to have a Roth account with an ESOP, the ESOP had to have a 401k feature, or known as a KSOP. And then it had to have an in-plan Roth conversion. The difference between Secure 2.0 is now the ESOP does not have to allow for employee contributions. And this Roth change will allow them to make the election on a contribution by contribution basis.
We've reached the end of our hour, and to respect everybody's time, I think we need to, we'll let you go through the slides. The slides are available for you to download, and they're, please feel free to peruse them.
Yeah.
Jordan, do you have any closing comments?
I'll close with, I agree with Alan that the last few slides are probably the least important. We put them there for a reason. I will close with the very last one. So all of the amendments we just talked about today, or amendments to your plan, The Secure 2.0 says that you need to have that plan amended on or before the last day of the first plan you're beginning on or after January 1, 2025. This also conforms to the amendment date for the original Secure Act, which the IRS extended out to also 2025. So now the original Secure Act changes and Secure 2.0 changes. Your plan needs to be amended to the extent you've adopted certain changes by 2025, provided that, and this is a big provided that, you have to administer the plan in accordance with the amendments. So that is all in terms of our substantive topics. What I'll close with is thank you for joining us today. We hope the information was helpful to you and your organization. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We do use this feedback to plan future programs that are applicable to your business needs. And then the last thing I'll say is Alan and I are absolutely open to any questions. If you didn't get a question that you submitted in the Q&A, please feel free to email us, call us. And with that said, this concludes our webinar. Thank you for joining.